We got a big group today, so we're excited to have you all here. Thanks for joining us. First of all, I'd like to thank our sponsors for today. I'm going to start out with CMA, and Miss Kim, if you'd like to tell us a little bit more about CMA.
There you go. Can you hear me now?
Yep, perfect.
Okay. I think my finger's too cold and mute wasn't working.
You're all good. Good morning.
Anyway, I don't really have too much to say except just to address the board and all the boards that are participating today and thank them and commend them for that kind of commitment. A lot of people join boards for a lot of different reasons, and sometimes it is because they have a vendetta or a personal issue, and sometimes it's because what they perceive to be poor leadership. But I don't think that's the case with anybody that's out there today. I think by participating in this kind of education, you're different. You're a different kind of board member, and you're the kind of board member that everybody needs. Those kind of board members are people that are here to build on a promise of excellence for their community and building on a promise of strength and stability for their community and for their neighbors. So it's really important whether you are just beginning to build your community governance or you are at a pretty comfortable place, which doesn't last long, let me tell you. But if you are in that place, there's always still room for education on every level that you are, from the beginning of your board membership, to whenever that ends. So what I really just want to say is that all of us, this is a kind of a peculiar industry. We're very different than everybody else, but we have CAI as our touchstone for our education and support. So do you. And we have our professional vendors, our attorneys, our community managers that are all committed and educated as a team. So while you have your community manager, you also have a wealth of other professionals in this industry that are willing to help you and create a team. So having said that, I just want to remind you that we are all here at your disposal. So thanks again for attending, and thank you specifically for your volunteerism and your commitment to your community. I think that was more than a minute, sorry.
That's great, Kim, thank you. Go CAI, right? Team CAI. Love it. Bob, do you want to go next? CPN.
So I just wanted to take a minute and thank everybody for attending. We appreciate being part of this program and being the sponsor of this important program for board members and for managers and just for associations as a whole. We've been involved in CAI for quite some time, and we encourage you, if you aren't a member, to become one. And I will leave it on to the next person from here, but thank you for attending.
Thanks, Bob. Thanks for the plug for CAI too. I appreciate that. Mindy from the Smith Management Group.
Hi, everyone. Surprise. It's Mindy Phillips with Smith Management Group. We are an associate company, and I am one of the directors of Community Association Management here. So I wanted to welcome you to this Heartland presentation of the board boot camp best practices. And a friend of Smith and a friend of CAI and a friend of most of this industry in this area, Judy Rosen, is going to be a presenter today. It's always good to see Judy. I wanted to welcome you and tell you that whether you manage, you're on the board and you manage yourself, or whether you have a professional management company, that as Bob said, joining CAI can do more to ensure your success than just about anything else that you can do as a board member. You're part of a leadership team in a corporation, you're an elected official, a leader, and it's a lot of responsibility. So we're here at Smith Management to help you in any way that we can. We do have a plethora of services besides, of course, community management is our main industry, but we certainly provide emergency services, restoration, insurance solutions, real estate services, and other lifestyle services. So it's our honor and our privilege, and we thank you for allowing us to sponsor today.
Thanks, Mindy. Thank you to all of our management companies that support us. We are appreciative of them being sponsors for our local education. So thank you guys for everything that you do. I encourage the sponsors to go ahead and turn off your video and mute yourself, please. Thank you. And now if you could advance the slide for me, Steve, I'd appreciate it. Thank you. I'd also like to take an opportunity to really thank our 2022 Diamond sponsors. They're all listed here. We appreciate their support. Without all of our advertisers, we would not be where we are today. So thank you. If you can support them, we'd appreciate it. So now we're going to begin with our fantastic panel of experts here. So we're going to pass it off to Diana. I think Diana is going to introduce Miss Judy Rosen, which we're so happy to have her back in the Heartland chapter. So thanks for coming back, Judy, for us. We appreciate it.
Judy, thank you, of course, for coming back to St. Louis, thanks to technology. Judy sets the bar high. Someone just said it while we were preparing, and that really says it all. She has spent more than 40 years in community associations and ultimately has dedicated herself to training and making managers the most informed and educated that they can be, all the way through her time in the DC area and ultimately after 1999 in St. Louis. And she has been the chair and a participant in CAM-ICB with credentialing managers from all levels and setting those standards. She's even taught the PCAM, the highest credential case study class. And we are thrilled for her to share her expertise and humor.
Thank you so much, Diane. It's a pleasure to be back in Heartland chapter again. Feels like home. So thank you for the very warm welcome. What I'd like to start off with today is a very quick little poll that each of you can take at your own home computer right now. Can we bring up those questions, please? Fabulous. It's an untitled poll, okay? So if you would just respond to each of the questions, I'll go over the first one with you. Number one, which would best describe you? Are you a board member or trustee? And if so, please complete the rest of the questions. If you're a community manager, please check the box. Or a business partner, please check the box. That helps us understand how many people are board members, how many managers and business partners we have participating today. So if you are a board member, please go on to question 2. The length of service on this board. You might have been on a previous board, but we're asking on this particular board. Is it less than a year, 1 to 3 years, 3 to 5 years, or over 5 years? If no response was required, you can check that box if you would like. Moving on to question number 3. Have you received any board training either through CAI or from your association's attorney? Again, a yes or no question or no further response required. And do you want to move the screen up a little bit to hit question 4? Diana, can you do that? And then the fourth question is, how is your association managed? Are you self-managed by the board and volunteers? Do you have a professional management company? Or do you have a combination of the two? Maybe you have the management company doing your financial management and the board trustees does everything else. So can we move on from the poll? And then when we get responses, Diana, will you be able to tally those and show us?
Actually, it's still, people are still taking it. I'm going to end it right now. We got it 64 people, so 80% participated, and we are going to share the results.
Wow, terrific. So 47% of those responding are board members or trustees. 39% are managers and 16% business partners. That's great. Length of service on the board, 22% is less than a year, 14% is 1 to 3, 14% is also 3 to 5, and we have 17% over 5 years. Very interesting. How about number 3, Kathy?
Yes, it says, have you received any board training either through CEI or from your association's attorney? Let's see, 27% said yes, 42% said no.
Interesting. 42% no.
That's correct.
And the
then-
last question?
Yeah, how is your association managed? We have 16% that said self-managed by the board and volunteers. 28% said by professional management company. 20% said a combination of the two.
Pretty evenly split. Okay, well, that was very interesting. Let's move on to the actual presentation, if you would, with the growth statistics. Thank you, Steve. So I think this is a very interesting chart. This shows in the United States only, nowhere else, the community associations include condominiums, which represent about 35 to 40%, homeowner or community associations, which is the largest group, anywhere from 58 to 63%, and cooperatives are about 2 to 4% of the total associations in the United States. And this information came from the CAI Board Member Toolkit. If you look at the number of communities in 1970, and many of you probably weren't even born in 1970. I hate to tell you, I was managing communities in 1970s. I was also living in a condominium community in the 70s. We had less than 1 million, 700,000 associations in the US, representing about 2.1 million people living in them. We just take a look at maybe line 1990. You went from 10,000 communities to 130,000 communities. You went from less than 1 million to 11.6 units, 11.6 million units, representing 29.6 residents. I'm not going to read every single one, but let's just look down at the bottom at 2020. You have 355,000 communities. In 50 years, you went from 10,000 to 355,000. You have less than 1 million residents to less than 1 million units to 27.5. And you went from 2.1 million residents to 74.1. This is indeed a big business. You as board members and trustees are responsible for a very big business. Whether you have a budget that's in the thousands or hundreds of thousands or millions or hundreds of millions, you are running a business. Thank you. Next slide, please. Let's take a look what all associations have in common. The governing documents. You have federal laws and state statutes. There are very few federal laws, and I'm not going to rain on Tony's parade. He'll be able to give you more detail on these. But the one that comes to mind is satellite dishes. That is regulated by federal. You have a plat that is recorded, which is the land description and buildings situated on that plat that is recorded with your state. For a condo, you have a declaration or a master deed also recorded. For a community association or homeowner association, that is called CC&Rs, which are covenants, conditions, and restrictions, again recorded. If you are a cooperative, one of very few in the St. Louis area, you have a proprietary lease or an occupancy agreement also recorded. If you are incorporated, and not all associations are incorporated, you would have your articles of incorporation, again, recorded with the state. Every association has bylaws. They are also recorded with the state. And then every association has some form of rules, regulations, or resolutions. 90% of the time, in my opinion, they are not recorded with the state, but sometimes you get one that is recorded, which is more difficult to change. Okay, next slide, please. The Board of Trustees or directors have 4 main functions. Can you go back one, please? Oh, okay, I'm sorry, 4 main functions. Number 1 is that you have to represent the entire community. If a perfect example is if you have a large scale homeowner association and you have like garden type apartments that are condos, you have villas or townhomes and single family homes all within the umbrella of that community association, and you live in a townhouse and you're on the board, your job is to represent the entire community, not just your section. Number 2, protect the association's real assets, including the building structure, parking areas, and all common areas. I'm going to get into this a little bit later, but I think fresh in everybody's mind is the association in Miami that fell to the ground last June, not even a year ago. The association had a duty to maintain its real assets. We'll talk about that a little bit later. And then you have your intangible assets. Number 1 among those is your reputation. Of course, your website, your electronics, your cybersecurity, emails, those are all intangible assets. Your third responsibility as a board member is to enforce the governing documents. And the 4th item is to build the social and civic well-being of the community. Thank you. Next slide. I should tell you all also, as we're going through these, you may have questions that come to mind. If so, please jot them down in the chat. All of the questions will be addressed at the end of the 3 presentations. So anything that I'm saying, or Tony or Chris, please ask your questions in the chat. They will all be answered. Okay. The board is elected by the owners, or if it's a new community, the developer may appoint during the developer control. I think some important things is the following. You need to have an uneven number of members. Size of board. Yes, size matters. You don't want a 7-person board for a 60-unit condo. That's not necessary. You probably could do it with 3. Third point, you need to develop rules for serving on the board if they are not specified in your documents. For instance, should we have term limits? If you ask me, I would say yes. You get a group of people on the board that have served for 15 or 25 years, and you need fresh perspective. So I would make my rules for that community with term limits. Another thing to consider, can you have multiple members from the same household? Can my husband and I both serve on the board? My opinion again, no. Let's make some rules that would eliminate that possibility. And the last thing about board members, can they socialize outside of board meetings? And Tony might address this about if there's a 5-member board and 3 of the board members go out for lunch, would that constitute a meeting? Because there are 3, which is the majority of the board. So again, I think you should make rules for serving on the board. Your documents rarely specify any of those characteristics. And I think it's very important that board members should consider all of that. Okay, next slide, please. Responsibilities, and this is for all of the board members, not just the president. You should go to an annual board member orientation. If you have a management company, they could be able to provide that for you. Your attorney, and certainly CAI, I know does orientations every single year, being today is one of them. Ongoing education and training, again, through CAI, your attorney, or the management company. The third point, and I get asked this question more often than I have ever dreamed, but can the owners vote directly for the officers? If there's 3 positions open on the board, can the board, the owners vote directly on one, Joe to be president and Bill to be the secretary and Tom to be the treasurer? It's very, very rare that you will see the recorded documents stating that you vote, the owners vote directly for the officers. In all my years of management, I have seen it only once, but I have seen it. So again, check your documents. The fourth thing that the board members are responsible for is to attend all board meetings. Those are the ones that are open to all of the owners. And the board also sometimes will meet in executive session. And I think Chris will probably talk about whether you should have meetings, minutes of meetings in executive session or closed board session. Tony may comment on it as well. From my perspective as a manager and one who teaches management, I would say you never take meeting minutes of executive session. And that is because any action that the board decides in executive session needs to be voted on in open session. You don't need to give the details. So for instance, if Joe hasn't paid his association dues and you've gone through all the procedures and the board votes to foreclose on Joe's unit, in executive session, that decision was made. It's allowed because it's a legal issue, a lawsuit in executive session. But when the board comes into an open meeting, that needs to be ratified in the open meeting. You don't have to give Joe's name because that would be disclosing personal information about Joe and his financial status. But what the minutes could reflect is that the board decided to file suit against an owner for foreclosure for non-payment of fees. And you don't have to list names or addresses, but any actions that you take in executive session need to be ratified in an open session. Next point, responsibility for a board member is that you must vote on all matters. You can't say, I decline to vote. You must vote on all matters, unless, and we get to the bottom, there is a conflict of interest which has been disclosed at the beginning. For instance, Joe's brother-in-law owns a landscaping company, and the board chooses to change landscaping companies. They haven't been satisfied. Joe discloses at the beginning of that conversation, whether it's 3 meetings ago or it's at the same meeting. My brother owns a landscape company. I hope you will entertain a bid from them. That's all Joe needs to do. He does not disclose any other information, and he does not vote on the contract. You must disclose any conflict of interest at the beginning of that discussion. Next slide, please. Responsibilities continued, provide continuity of board information to successor board members. So in other words, if the secretary has the way he or she does information, takes minutes, whatever, and passes that on to the successor when that person retires from that board position. It can be a binder of information. The responsibilities also include retaining advisors or professionals to represent the association. It could be the attorney, the accountant, the insurance agent, a reserve specialist, and the community manager. Have no hidden agenda. Well, that's one I would love to talk about. A board member, the association was just coming out of developer control, and the board president was the negotiator with the developer to plant, let's say, 100 trees throughout the community. And the next thing we knew, 6 of those trees were planted right in the vicinity of the board president's home. The others were scattered throughout. The board president had a hidden agenda, and that board president was asked to resign. Let me give you another example. Board president wanted to install a red umbrella on his patio. The documents clearly stated that any patio furnishings must be in keeping with the exterior paint colors of the building, which are all natural tones, earth tones. So a year and a half ago, the board president asked the board for permission to put a red umbrella, which can be seen not only from the ground, but from the units above looking down. And the 5-person board, and he only asked And he then recused himself. He didn't discuss the matter any further. He let the other board members discuss it. And it was not a very lengthy discussion. And the board rubber stamped his request and they let him put up a red umbrella. That was 1.5 years ago. Well, just 2 weeks ago, somebody else asked for a blue umbrella. And of course, I raised the question to the board, what was the board's thought process in approving the red umbrella? I'd be interested to know. And I didn't want the board member who had requested the red umbrella to answer, and I asked that he not answer. And the other 4 board members could not explain why they allowed the red umbrella. I then asked the board to consider, I then asked the board member to consider removal of the red umbrella because a precedent had been set and they were going to start getting questions for red, blue, green, orange, and purple polka dot umbrellas. So the red umbrella is no longer here. And the blue umbrella did not get approved. So don't have a hidden agenda. Next point, we're going to talk about committees later on, but board members could be a liaison to a committee, not a voting member. And why did you say not a voting member, Judy? And the answer is because when the committee turns down an owner for the red umbrella and the owner wants to appeal it, it goes to the appeals process, which is the board. So if you are the liaison to a committee as a board member, you've already voted no, you're not going to change your mind. So the deck is stacked against the owner. So you are a committee liaison, but you are not a voting member of the committee. More about committees later on. Next slide, please. The roles of, oh, by the way, there are 2 handouts and each participant today will get the handouts. One is a board member certification. And that's when you first get on the board, you certify what your role and responsibilities are. And that will be recorded in the board minutes book. The other handout that you will be getting is an actual agreement for board members. It could be used for staff members as well and committee members, which is, I will not participate in any discussion where I have a conflict of interest. So both of those documents will be going out after today's presentation. So let's look at the roles of the officers. The first one, of course, is the board president. And the board president is responsible for presiding over the board and annual meetings, setting the meeting agenda, leading discussion, and hearing all perspectives. And by all perspectives, the president can certainly just listen to board members, but I would suggest that he or she open it up to hear perspectives of the owners as well. The board president calls for a vote, and the board president votes on all matters, not just to break a tie. And that Chris may want to talk about that later, but that is one question I consistently get. The board president votes on everything unless there's a conflict. The board president signs legal documents. And most importantly, the board president is the face and spokesperson for the association. I want to go back to that condo in Florida, the Champlain Towers, which is in Surfside. I do not know all of the facts, but here's what I do know. The board knew that the building was shifting. They had monitors installed, and they could monitor the progress of the shift. There is no doubt that major structural repairs were required. I do know that the reserves were inadequate to make all of the repairs, and they did not want to special assess. What was the result? I do know 98 people in that building died. I do know, in addition, there were 11 others that were injured. I do know that there was more than $1 billion in property damage. Stay tuned. A year from this week, the trial begins. I can't give you any more than those are the facts that I know. That's a responsibility. That is big business. Okay, the vice president, next slide, please. The vice president fills in for the president when the president is not available in all of those things that I mentioned for the president. The secretary of the association is the corporate secretary. Secretary signs the legal documents. The corporate secretary sends out meeting notices to all owners of record. Another thing that the corporate secretary is responsible for is creating an action item list. And that you can easily get from the minutes of what is being discussed. And that is an ongoing list of who's responsible for what action. And hopefully you'll see the action has been resolved. The last thing is I also recommend a maintenance calendar and an administrative calendar. Again, the corporate secretary can be responsible for those items. Last, next slide, please. We have the treasurer. Treasurer collects assessments and sends out the bills, reviews the financial statements, and sometimes even prepares the financial statements, depending on whether you have an outside financial manager. Oversees the budget, oversees the reserves, oversees investments, and finds financing for large-scale projects. Did the condo in Florida consider financing? I don't know that fact, but that's one of my questions. If you have a large board, you may have other board members that don't have an officer position. Those would be the first that I would assign as liaison to committees. Next slide, please. Okay, we're going to talk a little bit about committees. Some committees are mandated in your documents, very few. There might be an architectural committee, a budget and finance committee, or an elections nominations committee. Those are the three that I most often see that are mandated in your documents. There could also be standing committees, which are for ongoing support to the board. You might have a social committee or newsletter communications committee, a landscape committee in buildings and grounds. Those are all several types of standing committees that are not mandated in your documents, but are important to the overall well-being of the community. And then a third type of a committee, which is an ad hoc committee, which I call a task force, is for a one-time purpose to support the board. When the task has been accomplished, the task force is disbanded. A perfect one of these is a decorating committee. We're going to redo the board conference room. What is a one-time assignment? When the assignment is done, the committee is disbanded. Okay. I just want to make one other, well, I'll make it on my next slide. Go to the next slide, please. The committee charter, you should develop a charter for each of your committees, even if it's a one-time decorating committee or a task force. The committee charter defines the purpose, which is the expected result of the committee's work, not what steps need to be done to fulfill the goal, but what your overall goal is. Your responsibilities are the activities and actions that must be performed in order to fulfill your purpose. Third point, how to recruit. And this is where I want to talk for a minute. You don't just let people sign up for committees. The board would be doing a disservice to the community. You need to know your community members. People have talents, and they should be able to count on those people, especially, oh no, I'm an architect, but I don't have enough time to serve on a board. Let that person work on the architectural review committee. It's perfect. Far less amount of time and demand on that committee member. So how to recruit. And I kid you not, this truly happened, I would say 30 years ago to me. An association was going to redecorate their party room, and they had a committee. And I kid you not, the chair of the decorating committee was blind, white cane and all. And that was the chair of the decorating committee. I don't know how that happened. Happened way before I joined that organization, but that was the person. So how many people do you need on a committee? What is your method of selecting the chair? Do the committee members select the chair, or does the board appoint the chair? How long is the term of office? What is the role of the liaison to the board? And who's taking the minutes and having those minutes reported back to the board? The fourth perspective of a committee charter are the day-to-day operations. How frequently do we meet? Where? What time? How many meetings do we need? And how do we get the board's approval to use the funds that they've allocated for the project? Thank you. Go ahead and move to the next slide. I would just want to talk a few minutes about a community manager. I know some of you are totally self-managed. So not every community has or needs professional manager or management company. So the board is responsible for everything. If you do have a manager, either for some specified functions or overall management, make sure your contract specifies what the board and the agency have agreed to. Maybe attach a job description. What are the spending limits? If, as a manager, do I need to go to the board every time I need $100? Or do I have authority to spend, replace the hamper in the gym for $50? Can I just do that when the hamper's falling apart? Or do I need to have board authorization on every dollar spent? Who approves the routine invoices? Who signs the checks? Who approves routine requests? And you must advise the board. That is your role as a manager. If a board wants to do something and the manager is really against it, like the red umbrella, should the manager speak up in the board meeting? I say yes. The board wants to approve the red umbrella. I would say, hold on here, board. You're opening a can of worms. I don't think you ought to approve the red umbrella. And have it recorded in the minutes that the manager opposed the board's vote. That stops boards dead in their tracks 90% of the time. A manager is bright enough to know the board's getting in trouble by doing something like that, and the minutes need to reflect it, because otherwise they could come back and say, well, the manager didn't say anything. Protect yourself, managers. That's what I have to say to you. I think that's the conclusion of my presentation. I thank you for your time. Everybody will get a copy of everything. And if anybody ever wants to contact me, Kathy can give you my email address. So thank you very much, Heartland. Appreciate it.
Judy, that was terrific. Thank you so much. Such practical information for all of us in there. Really terrific. And everyone will get a copy of the slides and handouts from each of the presenters, along with their participation certificate for their continuing ed in an email after Kathy gets it all together.
Yes, ma'am.
We're going to move on to Tony Zukanik, our legal advisor for our gold standard panel here. And Tony is with Sandberg Phoenix, has been for a lifetime. He's the father, one of the founding fathers of our CAI chapter. We're most appreciative and thank you. And he continues to be involved in the CAI law seminars, as well as your all-out corporate attorney with all corporate strategies. I'm going to let him get going. He also has a background in accounting. So like I said, kind of covers it all. Have it, Tony, on governance.
Thank you. Thank you, Diana. And Judy, thank you for that lovely presentation. As a counselor of law, as a mediator, I've come to the conclusion that people won't hear me until their questions are answered. So there were a couple questions that I want to just kind of address, and then I'll weave it into my my presentation. But you know, one of the questions was, you know, what is it that you know, a board, what kind of vote does a board require an entire community to act? Now, what you're going to hear in my presentation is your documents. Judy was talking about the universe of documents. That those ultimately are interpreted under contract law, and that's the extent of your authority. So if you can find the authority within those documents and it's unambiguous, that it's clear that you have the authority to act. I'll give you an example. You may have the authority to borrow money without the permission of the owners. If you have that authority within the documents, then you don't need a vote. If you have the authority to hire a manager without the owners, you have that authority to do it without a vote. If you have the authority to address a condemnation issue, frequently that happens. MSD, MoDOT, they need some of your common ground. You have the authority to settle that case. If in fact that authority is woven within the contract of your documents. Some of the other comments, let me just follow up a few of them, and then we'll get into my program. one of the comments that Judy made was a comment about 3 or more people meeting at a meeting, just impromptu. A lot of the comments I would have to address things of that nature has to, as with some of these issues on executive sessions, is that your declarations and if you have bylaws, oftentimes won't be specific enough to address that. So the board may have to adopt rules, internal rules for how it will conduct its meetings. So once you adopt those rules, that's what you will use to conduct yourselves. And if in fact the meeting requires, if you've agreed within your documents, or you've agreed that all your documents will be open meetings, then if you had a quorum of your board meeting without notice and it wasn't open, then of course you're in violation of your own rules. So those are some of the things you might want to think about as you address your meetings. Having some kind of, if you're going to keep minutes within your executive sessions, and again, those same rules will address what kind of minutes you keep, you want to keep them somewhat, limited, so that, because you need to assume that any kind of minute that you have, whether it's executive session or not, is discoverable. And my counsel to our clients has always been to be transparent. But there are obviously the needs to have some things done in executive session, like dealing with litigation or potential litigation. And some of the rules you can address in how you conduct yourselves may be that all your votes, like Judy suggested, are taken in open session. When I served on the board of MSD trustees, our rules were and were guided by the Sunshine Act, but boards are not guided by the Sunshine Act. But as an example, our rule was, once we accepted a contract in executive session, it had to be public within 24 hours. So that you can make internal rules that may deal with it in the same manner. So I think that addressed a lot of those questions. I want to go back to the ESG, the beginning of that slide, who's ever in control of my drive. Yes. So, when I was involved in founding the local chapter of the Heartland Community Association, the acronym ESG, or those initials, didn't exist. But I've had the good fortune of being part of a international group of lawyers and CPAs, and I co-chair the compliance division of that organization. And ESG has been a topic of conversation the last couple of years, and really woven into the manner in which the Fortune 500 corporations conduct themselves. But it's not limited to Fortune 100 or 500 corporations or just the international scene. If you really think about it, and you'll start to hear more about this, what we do in community associations is ESG. We deal with the environment, we deal with the social aspects of our associations, and we deal with governance. Governance being the end all. It's the beginning and the end of how we do everything. And to the extent we're involved in social or environmental, it's through the governance, it's through those universal documents. Next slide, please. So, unlike municipal law, our law dealing with associations is contract law. And at the end of the day, it's the unambiguous meanings of those covenants, which will, in the plain and ordinary and usual meanings, which will be upheld by the courts. And I gave you a couple cases. And it's very important to just keep in mind that your duties should not be expanded beyond the plain meaning of those documents. And next page, please. So let's talk about those. Judy, this is very similar to Judy's list. A lot of people forget that a lot of these subdivisions were farms before they were platted as a subdivision. And in order to be allowed to be platted, the municipality or county passed a zoning ordinance specific oftentimes to that particular subdivision. And people are unaware that that law for that particular subdivision is still the law guiding your subdivision. And and you should always try to obtain that and always circle back to that sometimes, because that law may have embodied certain things. As for example, it may have said who is responsible for maintaining a retaining wall or the streets or the conditions upon which that subdivision is allowed to exist. So it's more than just legislative history. It is a live ordinance that is law that you must abide by within your association. But that's the law that allowed the plat to be recorded. And when the plat was recorded, the governmental officials signed off on that, as well as the owner of the property, the developer, as we know, the company. And it will reference the declaration or the indenture of trust, or the covenants as they may be called. And likewise, the declaration, the indenture of trust, will reference the plat. So sometimes that doesn't happen, and we have to work within the confines of that. Won't go into that in today's seminar, but there are ways to address that situation. Sometimes there are bylaws, and the bylaws are always there if the association's incorporated. I've seen bylaws for unincorporated associations. Sometimes the drafters of these documents confuse the concepts, but at the end of the day, the bylaws should be the housekeeping mechanism of how you take care of your duties as board members and how you conduct yourselves as a board and how you conduct the meetings of your member meetings. And the declaration, the indentures, the covenants, those should have the substantive rights of the owners, the negative covenants, the duties of the board members, of the duties of the board. Usually we see people slip in some of the substantive rights in the bylaws because it has often a lower threshold to pass. It's not always the best way to do it. It's not a best practice. And that's what our conversations are today. But I want you to be aware that it's not surprising that we find some of that from time to time. Rules and regulations come from the declaration, the indenture of trust, the covenants, and or the bylaws, where they refer to the board's power to adopt rules and regulations. And what we're guided by when we do rules and regulations are general principles of fairness. Did the board, or did the members, as the case may be, as it applies to the rules and regulations, did they get proper notice of these rules and regulations? Did they get an opportunity to weigh in on them? Did they get an opportunity to object or say something otherwise? And was there a time period between the adoption of the rules and regulations and those becoming part of your quote law in dealing with your members? And then is there an opportunity for an appeal if there's a violation of the rules or regulations? So really, at the end of the day, you have to give multiple opportunities to the owners to be heard. Next slide, please. So I mentioned, and Judy did as well, associations come in two forms: unincorporated and incorporated. Now, notwithstanding the fact they're unincorporated, they all have a duty to file a tax return under IRS code 528, and they can do an 1120 or an 1120H. And that's part of compliance. It's just by filing your tax return annually. And also, if you're incorporated, it's usually as a nonprofit. In the state of Missouri, it's found under Chapter 355. And when you elect to be a nonprofit, you elect either to be a mutual or public association. You would prefer to elect mutual. The advantage of being incorporated is it's an entity to be sued or to sue. If you're unincorporated, then you have to sue in the names of the trustees. You know, there's an uncomfortable feeling when you're serving as a volunteer and you're named in a lawsuit, even though it's in your capacity as a trustee. It somewhat gets personal, and you're dealing with neighbors that you have to live with the rest of your life, that you're in that subdivision, and keeping it at the corporate level takes away some of that personal approach, and it keeps it at the level of the entity. It's a corporate shield. It gives another set of governance, because sometimes the declarations don't cover everything you need, and the Chapter 355 will address some of those issues. The bylaws, the first set will be adopted by the board. After that, it requires 50% or more of the members. That was a change in, I think, 1995. So if your bylaws say the board can amend them, that was usurped by the change of the law in 1995. There was a question that came up: do bylaws need to be recorded within the county as the indentures are? You know, my opinion is no. However, if it started out that way and people did record them, then I would continue to record my bylaws. However, if they were never recorded, then I prefer not to record them. I usually just keep recorded the declaration and its amendments. I've been told we're a not-for-profit, and I maintain it's a nonprofit as shown on the Missouri Governor website. Is there a difference? I've been told we're a not-for-profit, and I maintain it's a nonprofit. Not-for-profit and nonprofit, the statute says nonprofit, but it's the same thing. It's a synonym of sorts, but the statute is the nonprofit statute, state of Missouri. So, what are the definitions and differences between all these documents? So let's just kind of go back through that for a second. The declaration is often referred to as a declaration of trust, or declaration, or indenture of trust, or covenants, or CC&Rs. They're all intended to be the same thing. They're all intended to be a contract to bind all the owners, okay? And the bylaws, as I said, are usually the housekeeping mechanisms of how you address your members and your board, and how you conduct your meetings, and how you do your business. Next slide, please. So bylaws can be amended if you're unincorporated, you're not bound by Chapter 355. And if the bylaws say that they can be amended by the board, then they can continue to be amended by the board. That would be the distinction. There is no annual registration if you're unincorporated, but again, you still have to file the tax return. Next slide, please. Community tax overlay districts. I want to just mention this because they certainly have become more popular over time. And I would say this about the tax overlay districts. We know them as SIDs and NIDs. There's also TDD, transportation districts. they are ways to levy assessments on the owners within a geographical limited area defined by a legal description, oftentimes the same as the legal description of the plat. And sometimes it's easier to form a SID or a NID to make improvements on a street than it is to get the votes that you need, because it may take 2/3 of the landowners by acreage as opposed to 2/3 by numbers. And so that's one mechanism, but you are now going outside of the universe of documents, and that would be a separate board. So I just wanted to bring this up so you can understand there would be a distinction. So next page, please. So one of the things I want to mention, and what I have done, you try to look for shortcuts when you practice law. Well, I think you try to look for shortcuts when you do just about anything, but when you've been doing this as long as I have, one of the things I try to do, I get several calls a week of new clients that want my opinion. And before I can give my opinion, I ask several litmus questions. Are you properly elected? Number one, so you can hire me. Number two, how many units you have? Number three, what's your assessment? I'm trying to figure out if they can afford me. And then finally, I want to know what authority they have. And so oftentimes the boards come to me and they don't have all their documents. And so I ask for somebody that has recently refinanced or recently moved into the association, and I ask for their title policy, and specifically I go to Schedule B2, the exceptions to title, and there should be listed all the documents that the universe of documents. Oftentimes the ordinance will be listed that created the subdivision, the plat, book and page number will be listed, the original declaration or covenants will be listed, and any amendments should be listed. And that way I know when I'm looking at the document, I'm looking at the documents, I'm looking at all the documents. And believe it or not, so oftentimes people will give me an unsigned set of indentures to review or covenants, or they will give me something that's outdated, not realizing that it's been amended. Next page, please. So Judy alluded to this properly. It is fair to say there is no specific statute for homeowners associations except the Condo Act, and that only applies to condominiums. However, the Nonprofit Act, Arbitration Act, Title and Conveyance Act, Deeds of Trust Act, the Plat Act, Condo Act, statutes on condemnation, the employment laws, and the income and sales tax laws are all laws that associations have some responsibility to and can be guided. And I didn't include on this list, but Judy mentioned the Cable Act, and that would come under the Federal Communications Act, as well as the Fair Housing Act. So those would be a couple others I would put on this list. Next page, please. So with condos, people have the good fortune to have a little bit of disclosure when they buy a unit, and also at the level of resale. While our sales contracts in our community often have language that deals with disclosures, they don't get to the heart of what's happening in the owners association, and only in condominiums will you get that kind of information in a resale certificate. And it may be something that I will be trying to cause more of an evolution in my participation of the Bar Association and as a member of the Real Estate Committee, Contract Form Committee for SLAR, St. Louis Association of Realtors, where we might try to revive or change some of the disclosures to have some of the same things that you might find in the resale certificate. Because what an owner really wants to know is, am I buying into an association that's about to have a special assessment for things that didn't happen over the past? And that would be a negotiation point between buyer and seller if the buyer knew this. Next page, please. So, you know, especially in my larger associations, you really would like to have an organizational chart. And I think it's really important for board members to understand that the board has to act as a body unless specifically that authority has been delegated to a board member by that board or by the bylaws or by the declaration. And oftentimes the board really just has one employee or one contract vendor initial, you know, besides lawyers and other business partners, but mainly the property manager. And so the board has to act as a board when addressing the property manager, hiring the property manager, and giving instructions to the property manager. Imagine 3 board members or 7 board members telling a property manager what their opinion is or what to do. If that was to happen, it creates chaos. And it is the beginning of that organizational chart, that board has to recognize they have to act as one body, and only one message should be sent to the property manager. Likewise, if that property manager has employees for the association that's either employed by the property manager or employed on behalf of the association, stay in your lane. You hire the property manager has to address those employees. Board members that go outside their lane and they act outside and they start to give instructions to employees will eventually find themselves in a deposition. Let's see, let me catch up with some of the questions here. All right, I think I've addressed most of those. All right, next page, please. And I mentioned no one board member acts alone except as delegated by the bylaws or by board resolution. Next page, please. And an example would be if you're incorporated as a nonprofit and you have bylaws, it may say in the bylaws that the president has the power to hire and fire. Okay. If that was the case, the board should recognize that and maybe dilute that so that the board has a vote on that. You know, a lack of governance brings unintended consequences. The easiest way to attack an owners association lawsuit is to challenge the incumbency of the board. What I mean by that is, was that board properly elected? I can promise you that if we had the time to interview everybody that's in this program today that's attending, and I asked those board members, were you properly elected? More than half of those boards will say, I can't get a quorum, nobody showed up, no one else wanted to do it, therefore I just went, you know, I became the board member. The challenge with that is dealing with the every day-to-day business may be fine, but if we're going to be in a court of law and you want to attack the association's you know, ability to proceed, if the association wasn't properly elected, how could it hire the lawyer? How could it file the lawsuit? I think you can start to see how you can gut a case if there's a lack of governance. Next page, please. Always remember, a restrictive covenant is a private contractual obligation, generally governed by the same rules of construction applicable to any covenant to contract. This comes from an association case. Next page, please. So, just bringing up a more recent case, the Supreme Court weighed in 2019. And what they did was, for so long, as counselors of law, all we could do ever since the River Bend case that revived a case that was almost 100 years old, all we could ever do was say, if you're going to create a new burden, if it wasn't in the indentures, just amending it may not allow this burden to proceed. But the trustees of Clayton Terrace were successful in getting, and I don't think they were asking for this, but they got this. That's the unintended aspects of litigation. And what they received was language that was very favorable. And it said, when a contract is unambiguous, it unambiguously permits amendment or alteration, there is nothing to construe. The contract may be altered or amended. Unless use of the word amended is in the context of a particular set of indentures indicates it's being used other than in its normal sense, amended has its normal meaning. And in that, basically, you could amend to create new burdens. So essentially, Clayton Terrace effectively overruled Van Dusen by narrowing its application to amendment language burdened with ambiguities. And so they said, basically, Van Dusen had ambiguities, and that's why we interpreted it the way it did in creating a new burden. And that may be the end of my slides. Let's double check. Yes, that is. Let me just see if there's any. So one of the questions that previously I don't think I answered was, what happens if there's term limits and no one else wants to run? Oftentimes the language in the indentures will say that you continue to sit in that position until another person is elected. So that person might be term limited, but would continue to act until it would be a duty of the board to continue to try to have an election until that election happened. That person would continue to act. What if the indentures allow for appointing board members if no one is elected to represent a particular village in the HOA? Well, essentially, a lot of times there is language in the indentures that will allow you to appoint if there is an absence, if a vacancy, or I think in this case, what this person might be getting at is sometimes the indentures are really like a master set of indentures, and that there should be a representative from each particular plat or village in an HOA. And if in fact the indentures give you that ability to do that, fine. If it doesn't, then I would suggest you seek an amendment in order to address that issue, because it will continue to impair your ability to properly govern your association. I think we got all of them. If I missed any, we can probably pick it up at the end. With that, I'll conclude. Thank you.
Thanks, Tony. And Steve, I believe you're going to introduce Chris.
Yes, our last presenter here for the day is Chris Dickey. She is a professional parliamentarian. Just to kind of give everyone a little bit of background, if you look that up, she's very well versed and experienced in the procedures of running an organization, which obviously the organizations we're talking about today are homeowner associations, condo association, co-ops, and the like, as they're nonprofit corporations in the state of Missouri, if they're incorporated, as Tony had referenced previously. And Chris's experience is, how do you properly run the organization, which going back to board meetings and annual meetings. So she's going to be able to walk us through, tips, tricks, procedures. She has a handout, which we'll be able to share with everybody as well. Some of the most common terms that you might be using in Robert's Rules of Order for your meeting. But I will turn this over to Chris and let her begin her presentation.
Steve, and good morning to everyone. I am going to just zero in on the annual meeting for a community association. There's a lot I could talk about in running meetings for community associations, but we're just going to look at the annual meeting today. And there are common components to annual meetings, and normally it's stated in there what happens at annual meetings. And so normally it is you get reports from officers, the management company, if there is one, committee reports, and then normally there are elections. And so to look at electing new people to the board. Sometimes the annual budget has to be approved at the annual meeting. And then there is a time for new business. So these things vary from association to association due to whether or not the association is incorporated or not. It can depend on the state of incorporation and then the provisions in the governing documents. So, Steve, can you move the next slide? And just like Judy and Tony, talking about governing documents, these are so important, and I think that's why the three of us all put this on our slides, is that these are so important. I won't kind of repeat some of the things that have been said before, but some of the things I want you to understand is there is a hierarchy to these governing documents. So this is the hierarchy listed. So the things at the top trump anything that are below them. So you cannot override a rule in your bylaws that is provided in your covenants or declarations, or you can't override something in bylaws that is in state statutes. So it's important to understand, do you have your rules in the right documents that provide for that? Now, one of the things that Judy and Tony did not address that I will is below Constitution and or bylaws is rules of order. Now, rules of order pertain to how things happen in a meeting. So the types of rules of order are really the parliamentary authority, and Robert's Rules of Order is the most commonly used parliamentary authority. I have been a parliamentarian for over 20 years, and in that time, I've only had 2 clients that did not use Robert's Rules of Order. So it's the most widely used. There are some other parliamentary authorities out there. Some are used more by governmental bodies, some of the different ones, but normally it's Robert's Rules of Order. Now, if an organization does not specify and adopt a parliamentary authority, then they're just operating kind of under some general parliamentary rules that there is no really agreed upon what those are. So you're really kind of out there. So my advice to you is to look and see, has your association adopted a parliamentary authority? And I would definitely recommend Roberts. Now, Roberts is around 700 plus pages. It's not a fun read. Even I can get kind of sleepy reading through it. But if you need to find something, it is in there. There are things that you might not know you need to address at some future point, but Roberts addresses it. So it really is something good to adopt. Now, there are times when there are things in the parliamentary authority that your association might disagree with, and you might want to run differently. And you do that by adopting special rules of order, and special rules of order trump anything in the parliamentary authority. Let me give you an example of that. Roberts says that in a membership meeting, so this would be your annual meeting, members get to speak twice in debate, and for each time they can speak for 10 minutes. So that's a total of 20 minutes. I know people that can do that. They can go on and on and on for that amount of time in debate. And that's really a long time. So a lot of organizations adopt special rules of order and limit it to 2 or 3 minutes per speech. And so that kind of cuts down some of the things. So if you don't like something in the parliamentary authority, you just adopt a special rule of order. And then I also touched on standing rules and policies. Those are more of how things are carried out, where things in your declarations, covenants, or your bylaws will be more structural on the governance side, and standing rules and policies are more about some of the just the day-to-day procedures of how you get things done. So Steve, next slide, please. So let's look at the annual meeting. Any successful meeting really depends on pre-planning. And so let's look at prior to the meeting, what needs to be done. You might want to call for member motions. And why you might want to do this is if you are incorporated, the state, and especially in the state of Missouri has a state statute that if fewer than a third of your members are present, then you can only conduct the business that was in your meeting notice. So that means that you can have no new business. New business is when members make motions. So if you normally run with less than a third of your members at your annual meeting, and for a way for members to make motions at the annual meeting, they would have to notice their motions ahead of time. So you can call for member motions. The board doesn't have to do that, but it's a practice you can do. Then there's the meeting notice. So you have to notify all members of the place, date, and time of the meeting. And there's a time frame that you have to do that. That's listed in state statutes if you're incorporated. And so you have to no fewer than 10 or no more than 60 days before the meeting if you're mailing by first class mail. And you have to include a description of what has to be approved by the members. So you have to kind of tell them what you're going to do. So if you're going to have elections, you're going to vote on assessment, raising the assessment or something like that, you include that in your description of the meeting. Also need to develop an agenda for the meeting. So what are you going to do other than have reports and elections? Or are you going to have some speakers come in? What other things are you going to do? And then prepare what you need for the meeting. So do you need sign-in sheets for people that come in? Do you need to have ballots, voting cards? Let me talk a little bit about voting cards. It's really important. If you don't use them, I think you want to think about it, because at any time of a community association meeting, you have extra people in the meeting. You might have not necessarily people who own the property, but they might be residents of the property. So if you have a person living there and their significant other is there, but they are not on the deed, you have to make sure that only the people who are homeowners and representing one vote per property, or if it's on a weighted system, how are you going to handle that? So voting cards are good because you make sure that people are who have a vote are the only ones that are voting. It also cuts down on the noise. If it's a contentious meeting, people who want to vote no on something normally will yell out and be more boisterous than those voting yes. So voting cards kind of takes the emotion out of voting. So I would suggest looking at that. Steve, can you, next slide, please? So let's look at the meeting. When before you start the meeting and you're at the meeting, you want to have member check-in. And so you're going to need to have a list of members who are supposed to be, who are the people who own these properties? Do you need identification? I've been to some meetings where you have to even show a driver's license and show that who you are, so they know if whether or not you can vote. Is proxy voting allowed? And if so, has a proxy been delivered to the association, allowing someone to vote for a member? Are members that are in arrears, are they eligible to vote or not? Then do you have materials that members need? So do you have like the minutes from the last meeting? Do you have agendas to pass out? Do you have reports, voting cards, ballots, whatever you need for when people are checking in? Are those materials available? Next slide, please. Okay, so then the order of business. This is the standard order of business for an annual meeting, but I will get into each one. I'll go through each one. So Steve, next slide, please. So first of all is the call to order. So when it's time for the meeting to begin at the specified time, the person running the meeting should rap a gavel or whatever and calls the meeting to order. And then you have a certification of notice of the meeting. So the secretary certifies that the required notice has been mailed or posted, so it can be a legally held meeting. Next slide. So then you have the declaration of quorum. So the person running the meeting, the chair, will determine whether or not the number of members who must be present. And that can either be in person or by proxy, if proxies are allowed. And so this should be in either your declarations or your bylaws as to what the that number is for a number of people must be present, so that you can legally transact business. Now, and it's really important that you take a look at this. You cannot suspend the quorum number. You can't adjust it. It can be amended. So what can you do if you don't have a quorum? Well, you can fix the time to which to adjourn, and that's a pretty technical term for setting another meeting in the future, let's say 2 or 3 weeks or next month, to try to have the meeting again and try to get more people to the meeting. You can just adjourn the meeting and say, we don't have enough people, so we're just going to adjourn. You can recess the meeting and try to go out and find people. You can get on the phone and say, hey, call some people and say, can you please come to the meeting? We don't have a quorum, and we would like to hold this meeting. Or you can take other measures to obtain a quorum. Again, trying to contact some people. Or you can realize that you don't have an official meeting. So that means you can't vote on anything, but you could give unofficial reports. You could have people give information, but you cannot vote on anything whatsoever. So you can just sit around and chat and all, but it is not an official meeting if you do that. Next slide, please. Okay, so then the next in the order of business would be the reading and approval of minutes. So if you've already distributed your minutes to all your members, either by handing them out at the beginning of the meeting or by posting them on your website or emailing them to people, then you don't have to read them. The presiding officer asks if there's any corrections, and then you just approve the minutes as read or distributed or as corrected. You can have a majority vote to approve them, but a lot of times they're handled where if there's just no objection, they are approved. There is a way too that you could approve them through a minute approval committee. So you could appoint a committee at a annual meeting to approve the minutes after the, and so you're basically delegating that responsibility to a committee to approve minutes if you would like to do so. Steve, next slide. Okay, so then you go into reports of your officers, your management committee and standing committees. And so At that time, you would have any correspondence that's been received is read or distributed. So if it's official correspondence and it's something that relates to the business of the association, it should be made known at that time. You don't adopt reports. The only report you would ever adopt would be the audit report. No other report is ever adopted because then you're saying that if you would do that, you're saying that everything in that report is a stance of the organization, of the association, and you don't want to do that. You definitely do not want to adopt the treasurer's report, because if you did that, you're saying that everything in that treasurer's report is true, and you don't know that. In fact, that's why you would have an audit. So you just file reports, or you receive reports, or when a report's made, after it's made, you just say, thank you, and then move on to the next report. If any officers or committees have any action items in their reports, then motions can be made at that time and voted on during the report or at the very end of the report. So you handle the business that comes from those reports at that time. Steve, next slide, please. Okay, then you have reports of any special committees. And so when you're making your agenda, you know whether or not you have a special committee. And so if you don't have any special committees, then this doesn't enter into your meeting whatsoever. But if you do, you have to determine, are your special committees scheduled to report? And then if so, then you're called upon them to report. And then when the special committee gives their last report, they are automatically dissolved. Now, special committees are also, that's the generic name for, it could be called lots of different things. So it could be ad hoc, task force, blue ribbon committees, whatever. Just special committees is the generic name for all those names. Next slide, please. So then the next item in the order of business is special orders. So this is what here you do things that you're required to do according to any things in your governing documents. And so if an example of this is elections. So a lot of times they'll say elections are held at the annual meeting. And so this is where it comes up in the meeting, is under special orders. You can make an item a special order for a meeting at the previous meeting. That doesn't happen very often at all. Usually the thing that happens is elections, or maybe the adoption of the and consideration of the budget might come under this area. And then the next order, next slide, please. And then new business. So this new business is where members can introduce new business by making motions. So this is where members make motions. This is not a time for open discussion in annual meeting. You have to have a motion on the floor before there is any discussion on anything. So this is where members make motions. And like I said, like in the state of Missouri, to have new business, you have to have at least a third of your membership present at the meeting to have new business. So if you start your meeting and you see that you don't have a third of your membership present at the meeting, then you would not even bring up new business. Now, one of the things I don't have on here, you might be wondering about, I don't have on here, some people incorrectly refer to it as old business. It's really considered unfinished business. To have unfinished business, you have to meet at least quarterly. So at an annual meeting, you would never have unfinished business. It's just too long in between meetings to bring something else up from a previous meeting. And then the last thing is adjournment. And so when all your business has been completed, the presiding officer just declares that the meeting's adjourned, or members can make a motion at any time during the meeting to adjourn a meeting. It can be a very strategic motion in, especially in community associations, at least some of the ones I've been to. A lot of times the ones I get called into are ones that are pretty contentious. And like I've had fist fights break out. So it can be a very strategic motion is to make a motion to adjourn. If the meeting is too out of hand, make a motion to adjourn. And by a majority vote, the members can decide just to finish the meeting. So that is the order of business. Next slide, please. I'm going to talk about elections since that is something that normally happens at a annual meeting. First of all, you have to have, before you can have elections, you need to have a nominations. You'd have to look at your governing documents to make sure how nominations are made. You can do it usually a couple different ways. In some cases, you might have a nominating committee, or you can nominate for each individual position. And it depends on what are you nominating for. Are you just nominating for general board members or trustees? Or are you nominating for specific officers? So you have to look at governing documents to see how it's done. Sometimes the members just nominate people to the board, and then the board ends up determining who the officers are. So do you complete nominations before each for each position before elections are done, or do you nominate for all of them and then ballot for each position? So it just depends on. So the other thing is, unless there's any prohibition in the governing documents, votes can be cast for any eligible person, even if not they've been previously nominated. So basically, you'd be doing a write-in vote. So if the person is eligible, if there's any requirements to be eligible for an election, you have to look in your governing documents to see if that is the case. Next slide, please. So when you're doing elections, if fewer than the number of proper number of people that receive a majority vote, or if there's a tie, then you have to do additional balloting. So when you're setting up for the meeting, you might have to make additional ballots in case you have to reballot on this. So all the names of candidates that are not elected remain on the ballot, and they stay on the next ballot, unless you've adopted some rule to remove some people. It is possible you can say that only the top 2 people on the ballot stay on the ballot, or anyone receiving less than a certain percentage of votes come off the ballot. You can adopt some special rules like that if you want to, but if you have it, then all the names of candidates not elected stay on the ballot. If a ballot vote is required, even when there's only one nominee for each office, unless the governing documents allow for a voice vote. So it's good to put in to your governing documents to allow for a voice vote. If there's only one candidate, it makes things go a lot faster. Next slide. Votes should be counted by a tellers committee. So it can be determined to put together a committee to vote, to count the votes. And you have to make a really sincere effort to determine the intention of the voter when counting ballots. Sometimes when people fill out ballots, they'll scratch things out or they'll do different things to them. I've counted a lot of ballots, and so I've seen all kinds of things that people do. So you really have to make an effort to make sure you determine the intention of the voter. Blank ballots are not counted. So if someone turns in, if you get a ballot that nothing's written on whatsoever, then it's not counted at all. And then there are things that are called illegal votes, and illegal votes are counted into the overall number of ballots cast. but they cannot be assigned to one. So they include when you cannot determine the voter's preference. And sometimes you have to turn that over to the entire organization if you to determine that. If multiple ballots are folded together, and it's very obviously that they've been folded together. If votes have been cast for an ineligible candidate, so maybe in your association it says you have to be a resident or you have to be a property owner for 1 year before you can be elected to the board. There could be different things. Or if you have term limits and your term's finished and so you're not eligible for, maybe you have to sit out for a term before you're eligible to be a candidate again. Or if you're marked for more than the allowable number. So let's say you have 7 people running for 5 positions and a ballot's marked for 6 instead of you can only mark it and you're told you can only mark it for 5, then that is illegal votes. So let's take a look at what on the next slide, what this would look like when you're counting the votes. So for a trustee, let's say there are 3 people running and it takes a majority vote to cast. So the number of votes cast would be 210, and we're looking to elect it could be 1 or 2 people, let's say. So the number of votes cast is 210. Now the number of votes cast includes illegal votes and legal votes. The number to elect is based on a majority of the votes cast. And then you list down how many votes each person received. And then you also list down the number of illegal votes and why they're illegal. So somebody wrote in Minnie Mouse, obviously that's a fictitious character. And so they received 1 vote. Steve Sharp received 2 votes. Maybe he had term limited out and is ineligible. And then ballots marked for 2 candidates. So in this case, they were told they could only vote for 1 person. So 2 candidates were not allowed. So in this case, Julie Adams received a majority of votes and is elected. And so that's, but it's really important. And I think as Tony said, if you have people who, if you're not conducting elections correctly, you could get people on your board who are not really legally a board member. And so it's really important that elections be run correctly. Next slide, please. Okay, some tips for annual meetings. I've been to a number of annual meetings and I've been to some that are have a lot of problems. So you really have to anticipate what the problems may be ahead of time. And it just depends on maybe what you think the business might be coming up. You can anticipate problems from previous meetings. So have you solved the problems from previous meetings and look for better ways of doing things? My suggestion is to write a script for the meeting. The person running the meeting will see that all kinds of things can be happening in a meeting and get them off course. And also some of these people aren't used to running meetings. And so it's not something they do all the time. It's not language they use all the time. And so it's really good idea to write a script out so you're doing it correctly and take a look at it. Adopt some meeting rules that just pertain to the meeting. So like I said, you might want to limit the time of debate instead of having 10 minutes for each person each time they speak in debate, limit it to 2 minutes. And then have a timer. Have somebody in charge of as soon as the person starts speaking, the timer goes, and then when they hit that time limit, they announce the time limit. And make sure it is enforced fairly. I've seen where sometimes where a person running a meeting, if they like what the person's saying, they'll let them talk forever. If they don't like what they're saying, they cut them off. And that causes all kinds of problems in meetings. One of the things I highly recommend if you have a contentious meeting is create a speaker spot. And I've done this in several meetings where I actually have taken some masking tape and taped out a little square on the floor. And if people want to speak in debate, they have to come up to the speaker spot. And if they can line up, if there's a lot of people want to speak, they'll line up behind this spot, and they have to come to this one place to speak. And I've done that because it's so easy for people to kind of sit in the back of the room and just kind of pop off and from their seat and say all kinds of stuff and be disruptive. A lot of people do not like to stand up in front of a group to speak, but they'll say anything from their seat and cause problems. Also, if they have to get up out of their seat to go someplace like this, they'll think twice about, do I really want to do that? So if you're having a contentious meeting, I have found that works at least to help. And you're more in control of only the person in that speaker spot can speak. No one else in the audience can speak at that time. Also, even in contentious meetings, it's important to create a friendly atmosphere. And because you're bringing together people that live close to each other, hopefully they're neighbors, they like to see each other. And so try to include some social time before the meeting, maybe some coffee and donuts. I would not include a happy hour. I've seen some drunk meetings go on, and that's including alcohol with some of these things is not a good idea from my experience. And then allow a time to welcome new neighbors. And just let people get up and introduce themselves, and let them say where they're from. Hopefully they'll start off by a welcoming environment for everyone. And then think about, do you need a microphone? A lot of times people say, oh, I can speak up, I have a loud voice, and a lot of times people in the back of the room cannot hear. In this time of COVID, I've been in meetings that have been out in pavilions and all that, and with outdoor noise, it's been hard. So I really recommend, really considering a microphone. It also helps people, especially if you have a speaker spot or something, that people have to come and speak on a microphone so everyone can hear them. So those are some of my tips for the meeting. Next slide. Minutes. Okay, we talked a little bit about minutes. So minutes for annual meeting, it's really important that for what I see is most minutes include way too much than what needs to be in the minutes. Minutes are just what was done at the meeting and not what was said. So you don't want to have any opinion or judgmental phrases in them. Motions should be recorded as voted upon and not how they were made. How they were made is where they start, and then the motions can be amended. So you just want to record it. You don't have to do the blow by blow amendments to them or anything else. You just record them as to how they were stated right when they were voted upon. You don't record any debate. You can put down discussion was held. A lot of things can happen when discussion is being held. Like I said, I've been to meetings where fist fights break out. You don't record that. You would just say discussion was held, the motion, and you record it as how it was voted upon. And then what was the outcome of the vote? It was adopted, it was not adopted. So minutes can be very, very simple, and they should be. A lot of minutes can be even written even before the meeting, and you just kind of insert what the motions are going to be. If you're going to have new business, that's where you might have an area where you're not real sure about what's going to happen. I would also recommend that if members are making motions, that you require them to write down their motions so they can be turned into the person who's taking minutes, so they know exactly what and also for the person who's running the meeting. I have been in a lot of meetings where a person gets up and makes a motion, and you can tell that they're thinking about their motion as they're doing it. And probably when they get done saying their motion, presenting their motion, they can't even tell you what they said. So if you make people write down their motion, they will, for one thing, probably think it out. They will write better motions, and you will, the person running the meeting will be able to restate the motion, and the person writing the minutes can record the motion. So that's important. And then when you get into when you actually put the minutes together, if you have any written reports, you can attach those written reports to the minutes. And then any correspondence that you have relating to the business of the association can be attached to the minutes. And also your teller's report can be attached to the minutes. And that's important to show that someone was legally elected, was elected properly to the board. So that's important. So those are minutes. I will touch on a little bit, because it was brought up before, executive session minutes, since I'm on minutes. Unless you've adopted some other special rules of order, you do take minutes at executive session. Those are separate minutes than the regular minutes for the meeting. And they only contain what was decided, or what was done at the executive session. To approve those minutes, the board would go into executive session again to approve those minutes. However, to do that, you do not take minutes of that executive session that is approving minutes, because then you'd get into this circle of no end to do that. And unless there's been rules adopted otherwise in your governing documents, you do vote on issues in executive session. If there's a motion in executive session, you would vote on it in executive session. So with that, I will turn it back over to our host, and I think they have some Q&A for us.
Yeah, Tony and Judy, can you come back on, share your video? Do we have any questions? Steve, Diana, Jennifer? I think we have a lot that has came through. I don't know if they were all answered though.
There's a number of them that were, but there's one that, and one question I've seen in here that actually is probably a good one to talk about, because from a national as well as local, someone was asking about what are the Missouri requirements for voting cards, proxy cards, or digital voting. So that might be an interesting topic to discuss.
What I would say is, if it's an incorporated not-for-profit, section 355.291 deals with proxy votes, and it was addressing the fact that in that section it says a proxy is only good for 11 months unless a different period is stated, and then it cannot exceed 3 years. So sometimes you just refer to the nonprofit statute if you're a nonprofit. As to the actual type of vote, electronic votes, and things of that nature, that's conducted by your bylaws or your rules and regulations. Again, it's all by contract. If within the declaration it says the board can prescribe how the meetings will be, the election will be conducted, then you have the latitude. If it doesn't, and you're incorporated as a not-for-profit, you do it through the bylaws. If the bylaws didn't, were adopted years before we had social media, then what you do is you have to have the bylaws amended to specifically address the medium in which you want to have the future elections.
So just to confirm, in the state of Missouri, for a lot of declarations and bylaws that I come across as a manager, they always say in person or by proxy. So in the state of Missouri, if it doesn't state anything about electronic voting, mail-in ballots, any other type of electronic means, we are stuck with people showing up to meetings or submitting a proxy, assigning their vote to someone else, correct?
Yeah, yes. However, I will tell you I can't give you the name of the case. There was a case that basically said if you met in spirit the process of the election, it would be counted, but you don't want to rely on that. You don't want to go to court to find that out. So again, the better way to deal with it is at the very least, have the board prescribe what the rules and regulations are going to be for the election. Now, how valid is that if there was no specific authority given to the board to do that? Well, it can be challenged, but at the very least, if you went through a process where you said, this is what the rules and regulations are going to be for meetings, and you gave people an opportunity to be heard, and then you gave time before it became effective, and then you abide by those rules in the future, that's far better than not having any at all, okay? The perfect world is to be incorporated as a nonprofit. The perfect world is to have it in the bylaws, and the perfect world is to have a vote of those bylaws to have the expanded language that you need in order to have the latitude to have the most inclusive meeting.
But we all know that we don't live and work in the perfect world. So
No.
Thank you for that guidance, because truly there's so many associations that have trouble even meeting quorum. You know, like there's not enough people. We talked a lot today about committees and how valuable they can be to an association and how much they can take off of a board member's plate. But the reality is that we don't have people that are volunteering to be on committees. We don't have enough people to volunteer to be on boards. We're not even getting nominations for filling board positions. It's getting to the point where we have to like appoint. And if the declarations don't give specific instructions on that, our boards are left with no guidance. So
And Jennifer, on that topic, there was one question that asked, you know, can you, if there's only one member, can you do it by acclamation? That's only if your bylaws give you that latitude. You still have to have the vote. You still have to have the process. You know, Chris was hitting it straight on about the governance and following the rules and the election. And, you know, if you don't have the quorum, what you do is you may take the votes that people are willing to cast and say that I'm going to hold these until we have a quorum, and you adjourn the meeting to a time specific. And you should always reserve the right when you're going to have a vote that the meeting's going to be on November 1st, and unless there's a failure to obtain a quorum, and in which case it will be adjourned for a period of 30 days, and the next meeting will be December 1st. It's really great to give that kind of information up front, but at the very least, you adjourn it to another meeting. And you find a mechanism where people you can count those votes that have been casted, and they have the right to withdraw them because you've exceeded you've continued the meeting to another date, and you got to keep some kind of mechanism to keep track of it. But whether it's for an amendment that takes 2/3 or whether it's for electing the board members, you just keep adjourning that meeting and to another date until you get the quorum necessary. The Nonprofit Act helps you in that regard, but it's best to try to meet the requirements that are in the indentures.
Tony, will you clarify what the update after 1999 did for the documents before that? For meeting quorum?
Are you're talking about the nonprofit statute?
Yes.
I have to look it up. So go on to something else. Let me look it up real quick.
There was another question in regards to there's been some confusion about executive meeting minutes and their approval. Can you talk a little bit about that, and should there be minutes of an executive session?
Yes, there should be minutes of an executive session. For any meeting, there should be minutes to record, so you have a record of what was done. But for executive sessions, so you would have separate minutes. And in executive session, everybody's honor bound to not discuss what was discussed with anyone who's not a member of that body. If you have executive session minutes, you have to keep them in a separate place. You sometimes you might keep them with your attorney, especially if you don't if you have property where you have an office, maybe a locking file cabinet or something, but you keep those minutes differently and separately and securely.
And Chris, while we're on the topic of minutes, one of the questions were, what are the requirements of minutes? Do they need to be signed? Do they need to record the names of who made the motions, or is it sufficient just to say a motion was made and seconded? What's the legal authority for these requirements, and what kind of trouble do we get in if we don't follow them?
Nowadays, minutes don't really get signed because they're usually done electronically. So it's not a hard copy. I'm sorry, I forgot your other.
Oh, sorry.
answer
So
the
if
question.
they don't need to be signed, do we need to record the names of the people who are making the motions and
making the
seconding
motions.
the motions?
If you have Robert's Rules of Order, Roberts says you need to put down who made the motion. However, a lot of organizations are adopting special rules of order to delete that, because a person can make a motion and then through the amendment process, it can turn into a very different motion, something that totally doesn't look like what the person who made the motion is. And so in that case, it really doesn't make any difference. So a lot of organizations have adopted a special rule of order where they don't even record who made the motion. And then it's just a motion was made and then it was adopted, it was not adopted. In any case, you never put down who seconded the motion. It really doesn't make a difference who put a second on it.
Let me just add one thing. Chris, I don't mean to dispute the fact, but I've always been advised not to keep minutes of executive sessions because any decisions reached have to be ratified in an open session. And minutes are discoverable under law. So there may be things in the minutes of executive session that you don't want discovered. So anything, I've always been taught not to put it in writing.
Yeah, I'm not sure where you got that. Robert's Rules of Order, and that's a parliamentary authority would say you do. Now, here's probably what the thing is. You don't want to put discussion. You would put the motion down. And so it's kept in special minutes, so it doesn't go into the general minutes, and they're kept separately. So you are recording the exact motion that was adopted, but you don't want discussion, and because that is discoverable. And so, I have a couple organizations that have court reporters, they do verbatim minutes, and I think those are horrible.
Yes, I would too.
Everything anybody says is on record. But you do need to record exactly what the action, what the decision of that group was. And then, but they are kept separate too.
I understand that. Just one more point while we're talking about minutes. A question came up years ago in an association I managed, and there were 5 members on the board, and one of them was a bit of a rebel. And one of the other board members made a motion to take that person off the board, terminate his position on the board, and appoint somebody to fill that term. And nobody else on the board, the other 3 board members, did not second the motion. And I got called the next day or whenever the minutes were transcribed, and the motion was made but didn't appear in the minutes. Why didn't that happen? And I said, because the motion was never seconded. Is that correct?
Well, it all depends. If it's a board meeting, Robert's Rules of Order has different set of rules for small boards. So boards of around 12 or fewer deal with different types of rules than larger boards. And in small board rules, motions do not need to be seconded. So it doesn't, there is no need for a second in there. So it depends on what kind of rules you're running under. And maybe any type of special rules of order that may have been adopted by that organization. So
Thank you.
So for a takeaway for all of our attendees today, who are board members, likely of the smaller boards, we can use Robert Rules of Order as a guideline to create our own special rules of order for our own individual associations and then follow those guidelines moving forward.
Good suggestion.
yes, definitely.
I have another question through text message to me. Why should or shouldn't you record the names of those voting and how they voted? Anybody want to answer?
Crickets.
You know, I would say unless there's a requirement to do it, that's not the process. So if your indentures say you have to do that, then it's incumbent upon you to do it. Otherwise, I would say absent that, we have been raised in the society where your votes are anonymously submitted, and I think that needs to continue to be maintained. You know, you oftentimes have to do like a double ballot system so that you could register who voted, but not how they voted. You have a ballot within a ballot envelope, or you have a process where you can acknowledge who came in. That would be my answer.
That's for an annual election, but what about for our board meetings and the board member votes?
Well, for board meetings, people have to, they've been elected to their position. They have to stand on, they have to be accounted. They got to be accountable, and those votes should be acknowledged, specific to the person's vote.
Yeah, it all depends if they have rules adopted to, put people on record. If they're representing a like a village or a certain portion of the, then they're accountable to that. So maybe they do want to put them on record as how they voted. If not, if they're representing the entire association, then a lot of times that they're not put on, because even if you vote against something, if it passes, all board members should be supporting the outcome of a board vote. And I've been told, and Tony, you might want to comment on this, that unless it's something that if you're on a board and you feel that the board has done something illegal, then you should request that your name go in, that you are opposing it, to show that you believe it's illegal, and you want to go on record for that. Otherwise, normally everyone is supposed to be supporting the outcomes of the decisions of the board.
I don't disagree with that.
I know we probably didn't answer all the questions, but to be mindful of everyone's time, it's about almost 20 after 1. So if we didn't answer your question, if you want to email me and I can try to, email the panel to try to get an answer. I would like to thank all of our panelists. Thank you guys. You guys are experts in the industry and we appreciate you so much. Thank you to our sponsors, and last but not least, but thank you to Steve and Diana and Jennifer for helping behind the scenes. Without them, we couldn't have done this today. Steve, could you advance the next slide? I just want to go over our next webinar. So next webinar is next month. We're having handling high conflict situations. We have John Edwards from High Conflict Institute coming to talk to us. So you guys can register at any time for that webinar. $10 for members, $20 for non-members. We hope to see you then. Thanks, everybody, and have a great day.
Thank you.